Welcome to our guidance video for conveyancers that explains how you can avoid a requisition for restrictions from Land Registry. This is one of 8 videos that examine the problem, its impact and the action you need to take. About 20% of all requisitions sent by Land Registry are for evidence of compliance with a restriction. Other requisitions will have been sent for evidence where an application is made incorrectly for the cancellation or withdrawal of a restriction. The presence of a restriction in the register in favour of a lender who will be discharging their mortgage prevents our early completion policy from being applied. This is because the restriction prevents the registration of the new transfer and mortgage. In this situation, we requisition for either evidence of discharge or compliance with the restriction. In most cases, evidence of compliance or release from a restriction needs to be obtained from a third party, because the restriction is there to protect a right or claim in favour of the third party. Consequently, delays by the third party lead to many applications being lodged without this evidence, and a requisition has to be raised. Applications may eventually be cancelled. When dealing with a property, always check the register for any restriction and the wording of the restriction. Land Registry can't complete a registration where the evidence lodged does not satisfy the requirements of the restriction, so we will requisition for further evidence if this is needed. For example, does a restriction specifically require a consent? If it does, we can't act on a conveyancer's certificate. One particular type of restriction where delays are often encountered is the management company restriction. This is a restriction entered mainly on leasehold titles, which requires a buyer to, for example, enter into a deed of covenant with the landlord or a management company and pay a fee before the landlord or management company can give their consent, allowing registration of the sale to the buyer to take place. This is an area where significant delays in obtaining consent can occur. To some extent, where this type of restriction appears, a requisition is unavoidable because you are relying on a third party to provide the evidence you need to comply with the terms of the restriction. But please check what is required and make arrangements in good time to obtain that evidence. We are willing to accept requests for an extension of priority where there are clear problems with obtaining evidence of compliance. You show us what you have been doing to obtain that evidence and the cause of the delay. In October 2014, we changed part of our practice to try to help reduce the problem that can be created by restrictions on leasehold registered titles, such as when the restriction calls for the consent or certificate of a particular named lessor or management company, and that lessor or management company has changed, or the lessor or management company required to give the consent or certificate under the terms of the restriction has been dissolved. Such problems are not always resolved by simply disapplying the restriction in relation to a specified disposition, as this does not solve the problem for future dispositions. However, we have simplified the process for cancellation or disapplication where the lessor or the management company has been changed or has dissolved, and provided guidance to lessors, lessees and conveyancers that help them to apply for a form of restriction that will not create difficulties if the lessor or management company changes. There is more information about this in the supplement to Practice Guide 19. When drafting deeds, please think carefully whether a restriction is actually required, and if it is, how it should be worded. Is a consent or certificate required? For which types of disposals? Who should provide that consent or certificate? If there is a standard form restriction, are you applying for the correct one? Please consider applying for a standard form restriction wherever possible. Some non-standard restrictions are quite involved, and Land Registry is not in a position to determine whether parties have complied with complex requirements. It may be that in essence all that is required is for a certain person to give their consent. Section 43, subsection 3, Land Registration Act 2002 means that a non-standard restriction may not be approved if the registrar considers that its terms are not reasonable and it would not be straightforward to apply or would place an unreasonable burden on the registrar. Sometimes it is difficult to obtain evidence to comply with a restriction in the register because, for example, they have been worded too broadly and catch disposals when that wasn't the intention. They require the consent of a specific person or body which no longer exists. Remember that disposition has a wider meaning than just a transfer or charge, which may be all that you want to catch. The term disposition will also include a lease or deed of grant of easements. Our customers routinely apply for restrictions, especially in standard Form L, that go beyond the intention of the parties who are only interested in preventing sales. Frame your restriction carefully to avoid compliance issues later on. We appreciate that when drafting a restriction, you are representing a particular client, but please consider the future. If a restriction is required, ensure that it is both effective and that a third party will be able to obtain evidence of compliance in the future, provided they do the right things. As part of our recent change relating to landlord and management company restrictions, we have been encouraging customers to prevent problems arising if the landlord changes or a management company is dissolved by giving greater consideration when applying for restrictions. Clarified the process for applying for the cancellation of a restriction. The Form A restriction, commonly known as the joint proprietors restriction, gives rise to different problems. Firstly, we receive applications where there is no evidence about how joint tenants will hold the land. This is an avoidable requisition, as the dispositionary forms include a panel for you to complete. For example, panel 10 of Form TR1, Transfer of Whole. You can also use Form JO. We will write for confirmation if there are other requisition points. We asked for confirmation 3,769 times in one quarter. That's 2% of all requisitions. Rule 94 of the Land Registration Rules 2003 requires the proprietors, including applicants, to apply for an appropriate restriction where there is a trust of land and a valid receipt for capital money can't be given. There are other limitations on the trustee's powers. If there are no other requisition points, a Form A restriction is entered by default. This is because, under Section 44 of the Land Registration Act 2002, the registrar is under a duty to enter a restriction when he or she enters two or more persons in the register as proprietor of the registered estate. The appropriate restriction in this situation is the Form A restriction. That's Rule 95, subsection 2, subsection A of the Land Registration Rules 2003. This can in turn give rise to problems because an application is then made to remove the restriction. So both conveyancers and Land Registry can avoid unnecessary work if our customers clarify whether a Form A restriction is required at the time of lodgement. The second problem with the restriction is in removing it at some point later in time. There appears to be a misunderstanding amongst some conveyancers over when the restriction will be cancelled automatically following a disposal. We do not always do this. In one quarter, we raised 2,269 requisitions for evidence to allow a Form A restriction to be cancelled. This happens, for example, on a transfer from two proprietors to just one of them, which is not made for valuable consideration. Provided all is in order, we will register the transfer, but leave any existing Form A restriction in the register. Some conveyancers expect the restriction to be cancelled, but we can't do this without evidence of the equitable title and confirmation that the transferee is the absolute owner. It is not evident to us that the trust of land has come to an end. We will therefore require a formal application to cancel the restriction, accompanied by evidence that the restriction is no longer required. One of the biggest problems in practice seems to be a failure to appreciate that as well as showing what has happened to the specific trusts which led to the entry of the restriction, we need evidence to show that there are no other trust interests. The application should be in form RX3 with a declaration or statement which can be given in the RX3 or separately in the form of a conveyancer certificate. We have recently introduced form ST5 which can also be used to support an RX3 application. Using an ST5 also helps to ensure that all the requisite statements are provided. There are other types of disposals when a Form A restriction is left in the register. Don't always presume it will be cancelled automatically on registration of a disposition. As a rule, on a transfer of the registered estate not made for valuable consideration, or on a transfer of a share, a specific application will be required to cancel the restriction if it is no longer needed. For further guidance, see Practice Guide 19.